Hi, I'm Anna Denton-Jones of Refreshing Law, and as part of Knowledge November 2018, I want to talk today about what we do when we're suspending somebody. And certainly here in Wales, with the situation that occurred earlier in the year where Carl Sargent committed suicide, having been suspended from the Labour Party, it's given us all food for thought really around the extent to which we're talking to people when we suspend them and letting them know a little bit more about what's going on. Certainly I would always recommend that at the point that we have decided that suspension is a good idea, that we actually have a meeting face to face with an individual and we actually explain to them the reasons why they're being suspended in some detail, and rather than just perhaps sending them away with a letter telling them a little bit about the suspension process, that we actually explain all of that to them face to face and actually use that meeting as, if you like, the first stage in the investigation process. The advantage of doing that is when we have that conversation with somebody, it's likely to come as a bit of a surprise to them. We get the opportunity to get an initial reaction from that person. So, for example, we might get an initial admission of guilt of something, and maybe get a much more honest response from somebody than when we have sent them home for 3 weeks and they've had a lot of time to think about what they are going to say. So you get much more of a gut reaction from people than when they've had time to think up what they're going to say. So I would be making sure that we keep a minute of what is discussed in that meeting, keep notes, make sure that the questions that we've asked and the answers that we've received are recorded. In terms of what we're going to be telling somebody about their suspension, obviously we're going to emphasise that this is a procedural step at this point and that we're not prejudging anybody's guilt of anything, but that we have certain concerns and that certain matters need to be investigated. Now, your disciplinary procedure may set out how many days somebody's likely to be suspended for. It's very silly for us to give somebody the impression, for example, that they're only going to be suspended for a week if it's obvious from the outset that that is unlikely to be the case. And I think we're a lot better off managing somebody's expectations and explaining to them that, for example, you've got to bring in an external investigator, that there are a number of witnesses that are going to have to be interviewed, that this process is not going to be a quick thing, so that the person who is being suspended is aware and their expectations are managed from the outset, really, that this is not going to be a quick thing necessarily. Obviously, there'll be cases where you can do things quickly, but in a lot of cases, when we're suspending people, we perhaps give them the impression that the process is going to move a lot more quickly than it does in real life. And I think we'd be better off being quite upfront and honest with people about the sort of territory that they're in. We need to be explaining to people what the rules of engagement are whilst they are suspended. I've had a number of cases recently of people who were told not to contact customers, service users, employees, those sorts of rules as part of their suspension, and they've just completely ignored those instructions. So I think it is worth explaining what we mean by some of these things to people. And certainly when we ask people not to speak to employees, I think this can put people in a really difficult position, particularly socially, because a lot of people obviously have social media contact with their friends, outside of work contact with their work friends, and we shouldn't be trying to prevent people from having any contact whatsoever with people, but we should be emphasising that if they are in contact with colleagues, then not to talk about the contents of the investigation process, etc., but that, you know, they can go for coffee with their best friend. I think it's important that we send people away from a suspension meeting with a document confirming all the things that we've said. A bit like a redundancy meeting, people don't necessarily take in everything that we say to them then and there, so give them a letter or a frequently asked questions document that explains what's going to happen next to them. I think people, when they're suspended, can feel very vulnerable and as though there isn't anyone in place to support them, and that they're disadvantaged by that. So I think it is important that HR emphasise who can be contacted if they have questions about the process, and that you are there from both sides, if you like, to be able to explain these sorts of things. It's also worth talking about things like holiday and sickness during a period of suspension. There may be some holiday that's already planned, emphasising that somebody's still allowed to take that. What happens if they are unwell? They still need to follow your processes, they still need to ring in, they still need to self-certify, they still need to provide a doctor's note, etc. And obviously that they remain an employee, that they are continuing to be paid as such, and all of those sorts of things during a period of suspension. And that they must remain contactable, able to answer questions if necessary, and all of those sorts of things. If you need any support around writing a suspension letter, then please do contact me, A. Denton at Refreshing Law Limited, as in ltd.co.uk. Thank you very much.